Hello, welcome to the show. Late to work today. We're going to be talking about YNW Melly. He's on trial for double murder for killing his two friends. So his real name is Jamel Demons. Goes by YNW Melly. He's most known for his rap song called "Murder on My Mind," and clearly he wasn't lying. He clearly had murder on his mind this day, allegedly. So in in February 2019, he was charged with 2 counts of premeditated murder in connection with the October 2018 shooting deaths in Fort Lauderdale, Florida. Basically, the 2 people that were killed were his rap associates in the YNW crew, Cortland Henry and Anthony Williams. All right. So we're going to go into a little bit. So I have a lot of episodes to go into about this trial, but today we're going to be focusing on how I don't like the prosecution. They're dumb. They tried to so the defense motioned for a mistrial. And this is typical behavior. But the difference about this one is the judge actually had to think about it. Usually the judge just denies it. They try, they motion, and they deny it because the prosecution tried to basically accuse the defense and YNW Melly of paying off witnesses, which could or could not be true. But the judge made a motion that that can't come in, and they tried to sneak it in anyways. So, anyways, so that was prejudicial and it looked bad towards YNW Melly. All right, so I'm going to go into and play a little bit of them motioning for the mistrial, and we'll go from there.
Back on Tuesday, 9 a.m. Thank you.
And that's Melly right there. Give it a few seconds.
Let the record reflect the jury stepped down.
All right.
Counsel remain along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if it was, I don't think there's any evidence that she had something that might have been marked as an exhibit.
It was not marked on it, it was just a copy of the
So
transcript.
you're okay with it?
Yes, sir, I have plenty of copies.
In any event, so jury's been excused, counsel remain along with the defense, so you have a couple motions from this trial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do it, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise.
basically what they're talking about is so there's two things I believe they're talking about. So the prosecutor, which is that gal right there in the gray suit, she tried to basically accuse the defense of paying off witnesses, specifically YNW Melly's ex-girlfriend's mom, which they were paying her. They were taking care of her, but it's his ex-girlfriend's mom. I mean, I don't know what the laws are around that, but they tried to accuse them of paying her off, and the judge had already motioned previously that can't come in. Also motioned previously that certain comments from YNW Melly's ex-girlfriend's mom on Instagram could not come in, and the prosecution snuck them in anyways. And that's what the defense is upset about. I do have clips of basically what they're talking about, and I'll play that right now.
Your Honor, I object to this line of questioning based on the court's ruling.
Objection, no, it's overruled. Proceed.
So your testimony is that you have never been given money whatsoever.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For a vacation for all of us, for him, his wife, and me to pay for. As far as he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that.
Okay. So he did give you money.
Not for personal use.
Okay.
Excuse me, can we clarify who he is,
Objection, Your Honor.
Jameson Francois?
Objection, no, just clarify, counsel.
Sure. So it's clear, who is Jameson Francois?
He's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to know her by AA.
So AA and his wife.
We were all good friends.
So I'm going to show you now what's been previously shown to defense counsel and marked as stage triple M. It's a composite.
So basically, that's YNW Melly's ex-girlfriend's mom. So there was also Instagram comments. So she was saying on Instagram, she went on a tangent. Melly's manager said he was going to take care of me, and he stopped taking care of me. So fuck that. I'm going to be Miss Snitch Bitch. I'm going to be Miss Snitch Bitch. I'm going to snitch. And now all of a sudden, she's not saying shit. And it's gotten really tense with Melly's ex-girlfriend's mom. And anyways, I'm going to go back to a little bit about the motion for the mistrial. I just wanted that the prosecution was bringing things in that shouldn't have came in. Let me play another couple of videos just to see the confrontation. How many
Objection.
Objection.
So Ms. Holmes
This is his girlfriend's mom, ex-girlfriend's mom.
is the December 2018 statement that you gave correct and honest.
Objection.
Ask and answer.
Excuse me.
Dude. This was
I don't understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, let me answer the objection first.
Yes,
all
sir.
right? Objection notice overruled. Question is the statement, can you repeat your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that was
Excuse me, one at a time. All right? Just one at a, let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so.
She doesn't want to talk. Nah.
I don't know.
Hell no.
Would the audio of the statement of December 2018 help you?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me. Thank you. Not as to this. Go ahead. Overruled.
I don't know. I don't
remember.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Broward County?
Yes, I did.
Who did you come with?
My daughter Mariah.
Okay, where did you go?
We went to one of Janelle's ranch house,
And whose house was that?
Frida.
Okay. And now approaching what's been previously shown to defense counsel.
Anyways, she was just a hostile witness. She wanted nothing to do with this. Anyways, let's go back to, I'm sorry, let's go back to this.
That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state is essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what's that.
This is your motion for Mr. Armstrong?
Yes, it's our motion for mistrial.
This is the second one.
Motion
Well,
for mistrial.
it's the second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this.
Yeah, so basically the prosecution, as we heard in the last clip, they were saying, how much were you paid by the prosecution? How much were you paid? You know, and they already ruled that that can't come in basically. And there was another moment where they're like, how much did the defense they said they'll take care of you if you answer in favor of them, right? Yeah, you can't. That's a big accusation.
It's so improper. Not only
And this prosecutor is a maniac. Her emotions are getting into it. Like, I believe here in a minute, she's about to pop up and just look like a maniac. I don't like her.
does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, your honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot
Yeah.
and saw her today.
For the record, it was my first time ever seeing her in my life.
Yeah, they're pissed off, man. Rightfully so. Here she goes. Here she
Thank you.
goes.
Hold on,
Miss,
guys.
Miss
Counsel?
Psycho.
Yes.
Dismount.
Maybe not.
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they
No.
said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence, and there is no such thing. If it's admissible, admitted through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss.
Dude, I mean, it is somewhat standard procedure to motion for a mistrial, but usually the judge rules on it right away. But he actually said, I'm going to go think about it. I mean, I think that he was truly, really actually considering a mistrial. Basically, oh man, there's so much about this witness. I'm going to just run a video of her them just going insane. Like the prosecutor just getting all becoming a maniac on Miss Holmes. She didn't want to answer. I don't remember. Stop beating a dead bush. Anyways, folks, have a good one. Thanks for tuning in. All righty.